Good day, Crime Talk aficionados. This is Scott Reisch of Crime Talk, and thank you for tuning in. We have a busy docket today. First on the docket, it's always about the money. We're going to talk about Epstein and El Chapo. Second, what does the Felicity Huffman sentence say about fairness in our judicial system? And amicus curiae. A lot of organizations are filing amicus curiae briefs in the United States Supreme Court, urging them to take the case of Adnan Syed. Let's talk about it. Good day, Crime Talk aficionados. This is Scott Reisch of Crime Talk, and thank you for tuning in. If you like the channel, please subscribe. If you like the video, hit that like button and hit that notification bell so that you receive notifications of when we put up new content or we go live. Now, you're probably noticing this cool shirt. You can get the same shirt by going to the link and ordering it for you. And then I want you to send me pictures of you. First on the docket, it's always about the money. The disgraced financier, Jeffrey Epstein, signed a will just 2 days before his death by suicide earlier this month, assuming you believe it was a suicide. Court papers obtained by the New York Post show that the documents were filed August 8th in the U.S. Virgin Islands, where Epstein owned 2 private islands. They valued Epstein's estate at over $577 million, roughly $18 million more than Epstein had stated in court documents related to his bail requests months earlier. The documents also mention more than $56 million in cash, including his estate's total worth, according to the Associated Press. Epstein's will lists holdings that were not previously disclosed in other court documents, including aviation assets, automobiles, and boats, which totaled $18.5 million, as well as fine art, antiques, collectibles, valuables, which have not yet been appraised. These assets were transferred to a trust called the 1953 Trust, named after the year that Epstein was born. The documents do not list beneficiaries to the trust, though court papers note that Epstein's only potential heir was his brother, Mark Epstein, who has legal rights to his assets only if the will had not been filed. 2 other men, Epstein's long-standing employees, Darren Eindijk, a lawyer, and Richard Kahn, a businessman, were listed as executors of the will and were allotted $250,000 each for their work, as well as reasonable expenses accrued while they're performing their job as trustees. Now remember, Epstein was 66, and he was being held in the Metropolitan Correctional Center in New York City as he was awaiting trial on charges of sex trafficking and conspiracy. Epstein had pleaded not guilty to the charges, which carried a total sentence of up to 45 years. He was ultimately found unresponsive in his cell on the morning of August 10th. The medical examiner has ruled that the death was a suicide. In court documents seen by various news organizations, prosecutors on Monday asked the judge presiding over Epstein's case to dismiss Epstein's indictment in light of his death, and prosecutors asked the judge presiding over Epstein's case to dismiss Epstein's indictment in light of his death, and added that they tried to contact all of the identified victims of Epstein to relay the news of his death. Several of lawyers of Epstein's accusers have vowed to pursue justice, and he said they'll take the legal action necessary to get to his estate. Epstein's left no known beneficiaries, even in this known new will and trust. Lisa Bloom, who represents several women who have been allegedly abused by Epstein, states that the entire estate should be given to him. Now, you have to remember, Lisa Bloom is also one of the attorneys that represents Mr. Weinstein in his cases of sexual assault. Now, she is the daughter of Gloria Allred, and apparently it depends on who pays her, is depending on whose side is she really going to be on. Now, when somebody dies and the case is not final, the indictment is dismissed, so Jeffrey Epstein dies an innocent man, so to speak, as it relates to these new allegations. Now, the next case we're going to talk about also is always about the money. Drug kingpin Joaquin El Chapo Guzman wants to give his multi-billion-dollar fortune to the indigenous people of Mexico rather than forfeit it to the United States authorities. Now, during his high-profile trial in the United States, U.S. prosecutors from New York argued that El Chapo had generated at least $11.8 billion in cocaine, $846 million in marijuana, and $11 million in heroin during his 30-year stint as a leader of the infamous Sinaloa drug cartel. The U.S. government now wants him to pay back $12.6 billion made through the sale of drugs in the United States. But the demand is at odds with the Mexican president's Andres Manuel Lopez Obrador, who wants the cash returned to his country. And now El Chapo confided to family members that he hopes his multi-billion-dollar fortune will be distributed among the 15 million people that make up the 56 indigenous groups in Mexico. He expressed to his family over the phone his desire that the money that the United States intended to keep or that it has detected does not belong to the United States. El Chapo's lawyers made this evident in statements this past week, that the money should be returned to Mexico, and only plea to the Mexican president is that the money go to the indigenous people of Mexico. I guarantee it, the United States government is not going to give up billions and billions of dollars. The attorneys in the United States Attorney's Office literally get judged by how much money that they collect and they bring in through forfeiture actions, because that money kind of goes to the general fund and they get to use it once again for further law enforcement efforts. Do you think they're going to give up this money to go back to Mexico? Not going to happen. Why? Because it's always about the money. Next on the docket is the case of Felicity Huffman. As most people know, Felicity Huffman was sentenced last week to 14 days in prison for paying thousands of dollars to have one of her daughter's SAT scores inflated. She's the first parent to be sentenced in this new massive admission scandal. She's the first parent to be sentenced in a massive college admission cheating scandal wherein wealthy parents paid to get their children admitted to high-ranked schools that they might not have got into otherwise. Huffman was also sentenced to 12 months of supervised release and 250 hours of community service and to pay a $30,000 fine. There are no excuses or justifications for my actions, period, is what Huffman told the court in a statement released after sentencing. She also apologized to the students who worked hard every day to get into college and to their parents who make tremendous sacrifices supporting their children. Looming over Ms. Huffman's sentencing were questions about fairness and whether she and other mostly white parents in this case would be treated more leniently than poor or non-white defendants accused of educational fraud. The issues were emerging in a case that has been seeped with questions of inequality, as well as because this case involves well-to-do parents' efforts not just to guard their advantages, but to grab more. Prosecutors were seeking incarceration, pointed to other education fraud cases in which defendants were sentenced to prison time, and argued that anything less for Huffman would be essentially discriminatory. They noted the case of Kelly Williams Bolar, a black single mother in Akron, Ohio, who was sentenced to 5 years in prison for using her father's address to get her children into a nearby suburban school district. That sentence was later suspended to 10 days in jail, 3 years of probation and community service. And as noted, that after a group of black public school teachers, principals, and administrators in Atlanta were convicted in a conspiracy to cheat on test scores, some were sentenced to as much as 3 years in prison. If a poor single mom from Akron, who is actually trying to provide a better education for her kids, goes to jail, there is no reason for a wealthy, privileged mother with all her legal means available to her and financial advantages to avoid the same fate, is what the U.S. Attorney's Office argued. If we believe in just punishment, they argued, we should not put Williams Bolar in jail while letting Miss Huffman go free. The idea that one bad decision should be used to justify another in the name of public defenders generally don't wish for wealthy defendants to be treated as harshly as their clients are, but rather their clients to be treated with as much compassion as the wealthiest people. The attorney that represented Ms. Bolar was successful in seeking clemency in her case, said that there were indeed disparities in the justice system. When you are rich, and particularly if you are rich and white in this country, there's a different justice system, he said. But sending Felicity Huffman to jail is not going to solve that particular problem. And lawyers who represented an educator in Atlanta in the test cheating scandal don't give Felicity Huffman jail. Let the other people off with less punishment. Walter Pavlo writes that Huffman's sentence was indicative of other inequalities in the system, which have gained less attention. He pointed out that the entire case grew from an incident in which Maury Tobin was charged in a white-collar investigation and offered information about the college admission scandal to lighten his sentence. The prosecutors in the case stand to benefit from the high-profile prosecution as the prosecution offers a segue to private practice with big bonuses. While the media feigns outrage that Huffman received a light sentence, it has overlooked a justice system that is broken, one too heavily influenced by cooperators looking for a better deal and prosecutors hoping to parlay the cases they prosecute into a lucrative payday into private practice. Ms. Huffman got off quite easy. Did she spend hundreds of thousands of dollars trying to commit fraud? No, but she cheated, and she set the example for her children. All right? And justice is expensive, and injustice costs a hell of a lot more. And in this particular case, she thought that she could go in there and fall on her sword. She did well, not going to get you wrong. 14 days in jail, she'll live, she'll survive. She's not going to do hard time. Finally, the Adnan Syed case, the case that received huge following based upon the podcast Serial. Mr. Syed was granted a new trial back in 2016 and 18 based upon the Maryland Court of Appeals. A special court determined that ineffective assistance of counsel played a role in that particular case and that Mr. Syed deserved a new trial. Ultimately, the Court of Appeals decided not to reopen the case. Syed's attorneys have filed a petition to the United States Supreme Court asking that they order a new trial based upon new information that was not presented at trial. Now, an amicus curiae brief is a friends of the brief court, and the National Association of Criminal Defense Attorneys has filed an amicus curiae brief, a friends of the court, asking that this case be heard because the effects of this particular case could affect many cases down the road, because the decision by the Maryland Court of Appeals basically says it doesn't matter if someone was ineffective in this particular case and if the attorney didn't call them. But the standard for receiving a new trial is that the attorney was ineffective and that the information that was presented would have changed the result. Not absolutely, but possibly would have changed the result. National Association of Criminal Defense Lawyers, and out of full disclosure, I am a life member of that organization, has said that if that ruling stands, it could prejudice people who are seeking post-conviction relief throughout the United States, as it'll be cited as persuasive authority to other courts. This is going to be an interesting one to watch. We should know within the next couple of weeks whether the Supreme Court will actually accept the case. There are thousands of cases where a writ of certiorari is filed with the United States Supreme Court asking for review. Literally every year, thousands of cases. The United States Supreme Court hears 80 cases on their docket. So when you have organizations filing friends of the court type briefs, that's significant, and we'll see if Mr. Adnan Syed gets another day in court. That's all we have for Crime Talk for you today. I hope you enjoyed it. Please like, please sub, please subscribe to the channel. Hit that like button if you like the video. Leave us a comment. Do you think it's always about the money? Do you think Felicity Huffman got off easy? Was it too harsh? And do you think that Mr. Syed deserves another bite at the apple? Tell me what you think in the comments below. Have a great day.